Please all rise for the arrival of the Senate President and the Senators.
The continuation of the impeachment trial of the Honorable Chief Justice of the Supreme Court, Renato C. Corona, is hereby called to order. We shall be led in prayer by Senator Francis G. Escudero.
Thank you, Mr. President. Panginoon, sa muli po ninyong pagpapahiram sa amin ng panibagong buhay at lakas sa araw na ito, tanggapin po sana ninyo ang aming pagpapasalamat at pagkilala sa inyong biyaya. Sa muli po naming pagtitipon ngayon, ikaw po sana ang aming maging gabay at panuntunan. May you grant us the spirit of fairness, right thought, and speech. Teach us to look at, weigh, and appreciate different perspectives based on truth and reason. Please impart your supreme wisdom among all of us and guide us to make the best use of our own. This we pray in Jesus' name. Amen.
Amen. The Secretary will please call the roll of Senators.
The Honorable Senator Judges Angara, Arroyo, Cayetano Alan Peter Campaniero, Cayetano Pia, Defensor Santiago, Drilon, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Legarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revilla, Soto, Trillanes, Villar, the Senate President. Pimentel.
With 18 senator judges present, the presiding officer declares the presence of a quorum. The Secretary may na Majority Floor Leader.
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
The Sergeant at Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the March 15, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? Hearing none, the March 15, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. Please, the Secretary will now please call the case.
Case number 0022011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Appearances, Majority Floor Leader.
May we ask the parties for their, or to enter their appearances, Mr. President? Prosecution.
Good afternoon, Mr. President. For the prosecution panel of the House of Representatives, same appearances. We are ready, Your Honor.
Noted. Defense.
Good afternoon, Mr. President and members of the impeachment court. For the defense, Your Honor, same appearance.
Noted.
Mr. President. Mr. President, for a manifestation, may we recognize Senator Miriam Defensor Santiago.
The lady senator from Iloilo is recognized.
Thank you, Mr. President. It appears to me that we have come to the point in this impeachment trial when we are faced with the centerpiece of the prosecution, meaning to say the accusation against the filing of the SALN, Statement of Assets, Liabilities, and Net Worth by the Chief Justice. It appears to be the showpiece of the prosecution, and therefore we must take time not only take time out of number crunching, which you were doing last week, and see what the Constitution and what the Supreme Court have said about the filing of the SALN. First, let me begin with Article 2 of the Articles of Impeachment. I will read it verbatim. Respondent committed culpable violation of the Constitution and or betrayed the public trust when he failed to disclose, I repeat, when he failed to disclose to the public his statement of assets, liabilities, and net worth as required under Section 17, Article 11 of the 1987 Constitution. Notice that this heading under the Articles of Impeachment only uses the phrase failed to disclose. If we had disclosed and we are going to apply this article literally and very strictly, then there is no more case, because it turns out now that he disclosed his statement of assets and liabilities as provided by law, as I shall explain later. So in my view, Article 2 is suffering from at least incompetence in phraseology, because if we were to apply it strictly, if there is evidence, and evidence has been shown in this court, that defendant failed to disclose, meaning to say, failed to show his statement or make his statement of assets, liabilities, and net worth unavailable or inaccessible to the public, then he would have committed the impeachable offense. But if he already took steps to do otherwise, then the whole case falls. What I'm saying is that Article 2 should have said when he failed to disclose and he failed to declare, because declare and disclose are two separate things. As we shall see when we look at the Constitution, Article 11, Section 17, a public officer or employee shall, upon assumption of office, and as often thereafter as may be required by law, submit a declaration under oath of his assets, liabilities, and net worth. Notice, therefore, that the first requirement by the Constitution is to file a declaration. You declare what your assets and liabilities are. And then, in the closing sentence, the Constitution says, the declaration shall be disclosed to the public in the manner provided by law. This is the second requirement, the requirement that it should be disclosed. There are therefore two requirements. First, that he declared. Second, that he disclosed. It appears now that the Chief Justice both declared and disclosed, so the case is closed. But in the spirit of liberality, we have taken note of the explanation of the prosecution of its Article 2 on the Articles of Impeachment. Now, let us look at what our Supreme Court has ruled concerning the filing of the SALN under this constitutional provision. In the 203 case of Francisco versus Nagmamalasakit, etc., Supreme Court said a determination of what constitutes an impeachable offense is a purely political question. We cannot settle it by citation of authorities or by citation of cases. It is a purely political question, said the Supreme Court. The Constitution enumerates 6 grounds for impeachment. 2 of these, namely other high crimes and betrayal of public trust, elude a precise definition. But the issue calls upon the court to decide a non-justiciable political question, which is beyond the scope of its judicial power. Therefore, we are making history with this particular impeachment case. We are deciding a political question. What are the failures or the omissions in the filing of the SALN that would constitute an impeachable offense? Notice that in the United States Constitution, it is impeachable. It is possible to impeach a high public official for crimes, quote, and for misdemeanors. We did not use the phrase and for misdemeanors because misdemeanors in common law systems are mere faults or failures to observe minor ordinances. So our Constitution contemplates a very high crime. We have to see then what is the meaning of a high crime. In the records of the Constitutional Convention, we find at least this sentence. For graft and corruption and betrayal of public trust to be ground for impeachment, their concrete manner of commission must be of the same severity as treason and bribery, offenses that strike at the very heart of the life of the nation. They kept on repeating this clause in the Constitutional Commission, offenses that strike at the very heart of the life of the nation. That is, in pari materia, with all those other obviously high crimes that are enumerated in our Constitution. Our question, therefore, is not about how do you distinguish this value from that value, assessed value, acquisition cost, fair market value. We're not number crunchers. This is a quasi-judicial and quasi-political proceeding. This is not a quasi-accounting proceeding. So the question is whether there is any discrepancy or omission in the son of the defendant, Chief Justice, that strikes at the very heart of the life of the nation. Now I come to a famous, or according to your view, an infamous statement that was made by an American president during the attempt to impeach one of the most famous justices of the U.S. Supreme Court, Justice William Douglas, in April 1970. At that time, Gerald Ford, ultimately president of the U.S., was just a representative, and he maintained this infamous statement. An impeachable offense is whatever a majority of the House, or in our case, 1/3 of the House, considers it to be at a given moment in history. So we are actually writing the book for what is an impeachable offense. Conviction results from whatever offense or offenses 2/3 of the other body, meaning to say 2/3 of the Senate, just like the Philippine Senate, considers to sufficiently serious to require removal of the accused from office. So it is for us to decide what is impeachable in terms of the Psalm. Now, I have already made a passing mention of the Constitution. Let us go to the laws that are meant to implement the constitutional provision. The first law is called the Anti-Graft and Corrupt Practices Act, RA number 3019. Section 7, Statement of Assets and Liabilities. Every public officer within the month of January every other year shall file statement of assets and liabilities in the proper case with the office of the President, or in the proper case with the office of the Secretary of the corresponding House or the corresponding chamber. Next law, Code of Conduct and Ethical Standards, RA number 6713. The provision of the first law that we cited, Anti-Graft and Corrupt Practices, was expanded by the Code of Conduct. And it said the two documents, meaning to say the statement of assets, liabilities, and net worth, and the statement of financial disclosure. It says, and I'm quoting, these two documents shall contain information on the following. Letter A, real property, its improvements, acquisition costs, assessed value, and current fair market value. That's all that the law said. It did not indicate how we arrive at these values. It just says that the Psalm should contain information on real property, its improvements, acquisition cost, assessed value, and current fair market value. Who determines this? The proper public officials. So there is no need for this impeachment court to argue lengthily on what is acquisition, what is assessed, what is current fair market value. These are determinations made by the proper legal officer. And further, the Code of Conduct provides the Psalm shall be filed by, in the case of senators and congressmen, with secretaries of the Senate and the House respectively. In the case of justices, with the clerk of court of the Supreme Court. We have already heard evidence that the Chief Justice filed his declaration, and he filed it with the correct official, the clerk of court, from whom the public may see fit, by the proper procedures, to get a copy. Not only do we have these two laws to guide us, we have to look at its implementing rules and regulations, particularly of the Code of Conduct. The Code of Conduct, implementing rules and regulations, reflects the law itself, meaning to say the Code of Conduct, and providing that the statement of assets, liabilities, and net worth shall contain information on the following. And it repeats, real property, its improvements, acquisition cost, assessed value, and current fair market value. In the implementing rules and regulations, we find the following statement. In the event said authority determines that a statement is not properly filed, they shall inform the reporting individual and direct him to take the necessary corrective action. The individual to whom an opinion is rendered and any other individual involved in a similar factual situation and who, after issuance of the opinion, acts in good faith, underline, acts in good faith, in accordance with it, shall not be subject to any sanction provided in the code. Underline, shall not be subject to any sanction in the code. This is the basis for the theory by some that since any failure or omission in the SALT has now been decriminalized, it should no longer be considered an impeachable offense because of this provision in the implementing rules and regulations of the Code of Conduct. And there are certain provisions that are provided for failure to do so. Now, we have looked at the two laws. We have first looked at the constitutional provision. We have looked at the provisions of the two major laws, the Anti-Graft and Corrupt Practices Act and the Code of Conduct and Ethical Standards. Now let us look at the even lower level of legislation, the Civil Service Rules. You all know by now that the recent guidelines issued by the Civil Service Commission are supposed to govern declarations made for 2011 and thereafter. And there are definitions of terms in this guideline. But among the most salient provisions of the guideline is, for computation purposes of real properties, acquisition cost shall be used. That's what the law says. You use acquisition cost. In the past, people did not know what to put in their sums, and the law did not say anything. Then eventually the law said you can put either acquisition cost, assessed value, or fair market value. Civil Service Commission in practice ruled, although the conjunctive is used for these three values, the conjunctive of and, actually it should be interpreted as or, so you could just choose any of the three. But now we have in this new guideline by the Civil Service Commission that when we compute our real properties, we should use acquisition cost. There's no more question about this. If the public officer fails to comply with the law, he can be charged under the penal code with a crime of falsification for untruthful statements or for perjury. So we have taken a look now by this time at the Constitution, the applicable laws that are meant to enforce the Constitution. But let me go more deeply into the matter of the failure to disclose or the failure to declare or the omission of any declaration. The Civil Service Commission issued the recent guidelines that will govern 2012 and onwards. And it declares that for computation purposes of real properties, acquisition costs shall be used. So you and I, as members of Congress, of the House of Representatives and of the Senate, beginning from 2012, should now use acquisition costs for our son. But before this guideline by the Civil Service Commission, our bureaucracy was governed by the older guideline issued by the Civil Service Commission in 2006. 2006 resolution of the Civil Service Commission does not provide any guideline. The SALT filed by Chief Justice on 2011, but covering the period of 2010, as well as all his previous SALTs, was filed according to the old resolution of the Civil Service Commission. I have already said, and I repeat, according to Civil Service Commission, at that time, under the old guidelines, which was very deficient, or let us just say non-specific, it is not necessary to fill up all three values. You could just choose among fair market value, assessed value, and acquisition cost. Now let's come to the question, how should the current fair market value be computed? We have already been told that there are provisions in the local government code because the municipalities formulate a schedule of fair market values, and this is what is applied by the city assessors. In our present case, the defendant based the valuation of the assets in his son from the fair market valuation enacted by local ordinances. However, the prosecution contends that the defendant should have used the value by which a buyer is willing to buy the property and the seller is willing to sell. This is the argument that uses the antique, the age-old, centuries-old possibly, definition by an English writer called Sedgwick in his book Sedgwick on Damages, and cited in a 1919 case by the Philippine Supreme Court, defining market value as that reasonable sum which property would bring on a fair sale by a person willing but not obliged to sell to a person willing but not obliged to buy. I don't see what would be the utility of discussing what should be fair market value. We should be discussing the question of whether the defendant committed an impeachable offense when he allegedly erroneously misdeclared certain entries or completely omitted certain entries in his SALN. Let us see and I come now to the gist of what I really wanted to say. Let us come now to what the Supreme Court has to say. When you fail to properly and completely file your SALN, what are you committing? What crime are you guilty of? In the most recent case, 2011, Presidential Anti-Graft Commission v. Plato, spelled P-L-E-Y-T-O, PAGC versus Plato, promulgated in 2011, the Supreme Court answered, the failure is not dishonesty but only simple negligence. That prosecution panel should be the topic of your next oral manifestation, and particularly your written manifestation or memorandum at the end of this trial. Here is the Supreme Court speaking, and only as of 2011, Plato's SALNs are prepared by a family bookkeeper/accountant. Also, his wife has been running their financial affairs, including property acquisitions, which form part and parcel of her lending business. Thus, he was not directly involved, and he failed to keep track of the real property acquisitions. Here is the important sentence. Consequently, petitioner's SALN was not filed in proper form, containing several inaccurate information. The court had no doubt that the SALN was inaccurate, but it went on to make distinctions among these three terms: gross misconduct, dishonesty, and negligence. It cited the two standard laws, remember, that we began with, the Anti-Graft and Corrupt Practices Act, and then the Code of Conduct and Ethical Standards. This is what the Supreme Court said. For gross misconduct to exist, there must be reliable evidence showing that the acts complained of were corrupt, or inspired by an intention to violate the law, or were in persistent disregard of well-known legal rules. That's what you have to prove, prosecution. The Supreme Court went on, and as for dishonesty, it is committed by intentionally making a false statement in any material fact, or practicing or attempting to practice any deception or fraud in securing his examination, registration, appointment, or promotion. And then finally, negligence. Negligence, said the Supreme Court, is the omission of the diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. In the case of public officials, there is negligence when there is a breach of duty or failure to perform the obligation, and there is gross negligence when a breach of duty is flagrant and palpable. The Supreme Court goes on. Gross misconduct and dishonesty are serious charges which warrant the removal or dismissal from service of the erring public officer or employee, together with the accessory penalties. Hence, a finding that the public official is administratively liable for such charges must be supported by substantial evidence. Prosecution, you have to show at least substantial evidence, because this sentence was made in a decision that involved an administrative case, but we are trying an impeachment case. The Supreme Court held that Plato's failure in properly and completely filling out his SALN was not intentional. Supreme Court said, Clear from the foregoing legal definitions of gross misconduct and dishonesty is that intention is an important element in both. Missing the essential element of intent to commit a wrong, this court cannot declare petitioner guilty of gross misconduct and dishonesty. An act done in good faith, which constitutes only an error of judgment and for no ulterior motives and or purposes, does not qualify as gross misconduct and is merely simple negligence. And so, in the Plato case, the Supreme Court said, thus, at most, petitioner is only guilty of negligence. You have your work cut out for you. Prosecution panel, show that an omission or a misdeclaration was deliberately intended by the defendant. You must show essential element of intent to commit the wrong. Now, in another case, the court found that the defendant was guilty and should be removed from service. The Office of the Ombudsman v. Racho, also a 2011 case. So we have two cases to choose from because the latest case always controls the jurisprudence. In this other case, Ombudsman v. Racho, the court found Racho guilty of dishonesty for non-disclosure of his bank deposits in Saln. Here is a note of caution to the defense. Defense panel, has your client, the defendant, disclosed in his Saln all his bank deposits, peso and dollar deposits? Because if he did not, but he admits that he made those deposits, then under the ruling in Ombudsman, under the ratio decidendi, then your client is guilty. In this particular case, the Supreme Court defined dishonesty. It said, dishonesty begins when an individual intentionally makes a false statement in any material fact or practicing or attempting to practice any deception or fraud. And then finally, just for emphasis, one more case that challenges the position of the defendant. Carabeo v. Court of Appeals in 2009. He was officer in charge of the treasurer of Parañaque City. He accumulated several properties and was able to travel abroad 15 times. He did not disclose this in his Saln. He alleged as a defense that he can simply correct the entries made in his Saln. But the Supreme Court said that while the law indeed allows for corrective measures, the defendant was charged not only with violation of the Anti-Graft Act, but also violation of the Penal Code. He failed to show any requirement that prior notice of the non-completion of the Saln and its correction precede the filing of charges for violation of its provisions. I will now stop myself. I will challenge these two panels. Number one, prosecution, show that there is intent to commit dishonesty on the part of the defendant and you've won your case. On the part of the defense, show that your client has, in good faith, declared in his Saln all his deposits, both peso and dollar deposits, and if he did not, why not? Please take these cases, decided cases that I have cited accordingly. Thank you.
Thank you.
Mr. President,
The floor leader.
Mr. President, Senator Joker Arroyo wishes to be recognized.
The gentleman from Makati and Bicol, Senator Arroyo.
Thank you, Mr. President. I would not have spoken this afternoon had Senator Santiago raised certain questions. I will just follow that up. My question is this for both panels. Is a correctable offense an impeachable offense? I think that the two panels should think, because offhand that is what I am thinking. We don't have precedents. We don't have the law which implements the constitutional provision allows correction. So this is my, you don't have to answer it. I am raising the question for both sides to study it. Thank you.
Majority Floor Leader.
Senator Pia Cayetano wishes to be recognized, Mr. President.
The lady from Taguig.
Thank you, Mr. President. Mr. President, just a very simple follow-up from follow-through on the challenge posted by Senator Judge Miriam Defensor Santiago, and actually also Senator Judge Arroyo. I would like to know from both the prosecution and the defense if they in fact agree with the challenge posted by Senator Miriam Defensor Santiago. In other words, I think it's very straightforward, and can we simplify this? Because I saw the prosecution nodding, and if in fact you will agree with Senator Judge Santiago that in fact what you will simply prove is that there was intent to commit a dishonest act consistent with the Supreme Court ruling on Plato, then we are properly guided. Because I saw you nodding. And while you are discussing among yourselves, I also posed the same question to the defense that do you agree, are you prepared to make a statement that if in fact that you will prove that the defendant had disclosed all of his bank accounts in good faith, and if not, why not? Are you prepared to make a statement? Because that, to me, as a Senator Judge, simplifies the issue. And although Senator Judge Arroyo did not ask for an immediate answer to his question as to whether a corrective, a statement or disclosure that has a corrective remedy is impeachable, I would also like to know your statement on this, your reaction to this, if now or if not at a later date.
Your Honor, we will submit the memorandum with respect to that issue.
Okay.
Thank you.
And may I hear from the defense?
Essentially, we seem to agree with the presentation of Senator Judge Santiago, Your Honor. In fact, the direction at which we are taking in presenting our evidence is towards that.
Okay.
We just would want to state that under the SALN form, there is no requirement that we must have to indicate any bank deposits or bank accounts.
But it is...
And the Chief Justice has not yet made any pronouncement on this point, Your Honor.
But it is very clear to all of us, because that statement suddenly, if taken just if I take that statement in isolation, you're saying that the SALN doesn't declare a disclosure of assets, because obviously your bank accounts are part of your assets, correct?
No, Your Honor. It's just that my reading, and I'm not quibbling over this, Your Honor, does not require a listing of bank accounts.
Of the specific account.
Yes, Your
So
Honor.
let me rephrase my question. If I may, my understanding of Senator Santiago's statement is that there is a requirement that the defendant discloses their assets that are in the bank accounts. Now, I will not quibble also as to whether that specific account needs to be mentioned.
Yes,
but
Your
the assets, whether it is in your baol at
Yes.
home or it is in a bank account,
Yes,
the totality of that, at the very least,
Must
be
be
declared.
declared. Yes, Your Honor.
That one we have no argument on that.
Yes, Your Honor.
All right. Thank you very much.
Mr. President,
Gentleman from
another
Pampanga.
question. Oh, yes.
Thank you, Mr. President. Mr. President, just another point that I'd like perhaps both the defense and the prosecution to comment on if they should submit a memorandum. May we also have your views on the standard of conduct required of a member of the judiciary? Is it the same as to the standard of conduct, for example, of an executive official, or perhaps that of a member of the legislature? We'd like to see if we are comparing apples to apples. In other words, yung requirement ba, yung standard of conduct ba ng nasa hudikatura, parehas ba yan ng isang dating undersecretary ng Public Works, for example? Hopefully we can have that likewise in the memorandum.
Your Honor, we will include that in our memorandum.
Thank you. Majority Floor Leader, I think we better start with the trial. All of these matters ought to be submitted after the closure of the presentation of the evidence on both sides.
Just
the procedure in this trial is for the prosecution to present its case and for the defense to present its defense. Then, if there's a need for rebuttal, then so be it. And the memorandum, if at all, will come after the presentation of the prosecution's case and the defense rebuttal of the evidence of the prosecution. That's where we are at the moment. So the gentle lady from Iloilo is again recognized.
Just one word. In response to defense counsel's manifestation that it is their belief that the law does not require an itemization or a specification of the bank deposits of the filer or the declarant, I repeat, in the case, also 2011, I was citing the Plato case of 2011. In this case, this is also 2011. Office of the Ombudsman v. Racho, 2011. In this case, the court found Racho guilty of dishonesty for non-disclosure of his bank deposits in Sun. The court held that, quote, in this case, Racho not only failed to disclose his bank accounts containing substantial deposits, but he also failed to satisfactorily explain the accumulation of his wealth or even identify the sources of such accumulated wealth. And therefore, in view of these pronouncements by the Supreme Court, defense will now have the burden of proving that failure to disclose bank deposits is not necessarily an indication of bad faith to omit a significant amount of the assets of the defendant.
We agree, Your Honor.
So, Majority Floor Leader,
Mr. President,
may I suggest that we go on with the trial?
Yes, we are
and
now ready.
Let's hear the defense present the case for the respondent. We cannot judge this on the basis of manifestations or just the evidence presented by the prosecution unless the defense is ready to say that we waive our right to present evidence.
So, Mr. President,
And I don't think that they're going to waive that.
We are not, Your Honor.
Now, there are issues here that must be clarified. And that is what we are waiting for.
Yes, Your Honor.
Mr. President, we are now ready to...
As far as the presiding officer is concerned, there's only one standard for high officials and lowly employees of this government, and that is found in the first sentence of Section 17 of Article 11. To tell the truth and nothing but the truth in their declaration of assets, liabilities, and net worth. So proceed.
We're now ready for the continuation of the presentation of evidence by the defense, Mr. President.
Before we proceed, Your Honor, I just would like to make a manifestation. It is unfortunate, and we apologize that our Chief Defense Counsel is presently ill, Your Honor.
In this post.
In this post, Your Honor. So in the meantime, I'll be acting lead counsel for the defense, if the Honorable Presiding Officer would permit.
So proceed. We cannot control who is going to handle the defense of the respondent. You're the panel designated by him to present his case. Do so.
Yes, Your Honor. We have specific assignments in the presentation of evidence, Your Honor. So for the first, may we call on may we request that Attorney Tranquil Salvador be recognized?
Attorney Tranquil Salvador has the floor.
Magandang hapon po, Senate President.
Yes.
If I may proceed, Your Honor, last Thursday, I think the parties have agreed to enter into a stipulation on a singular document, Your Honor, in connection with the subpoena ducis tecum that was issued by this honorable court. And for the record, let me state it. It pertains to tax declaration number F-10002-35345 pertaining to CCT number 85716 issued by the Register of Deeds of the City of Makati, particularly pertaining, Your Honor, to unit number 31B of the Columns Ayala Avenue, Makati City, Your Honor. And Your Honor, in the light of this stipulation with the opposing counsel. Let me put it on record that the document was previously marked as our Exhibit 150. Okay? And, Your Honor, and I will refer to the market value and assessed value duly marked and stipulated on by the parties. The market value, Your Honor, is 1,210,000 pesos, which was encircled and marked as our Exhibit 150-A. Your Honor, I will also refer to the dorsal portion of the same document, which is the assessed value in the total amount of 726,000 pesos, Exhibit 150-B, marked and bracketed.
But what is the acquisition value?
Your Honor, the acquisition value is, there is no acquisition value, Your Honor.
There's no acquisition value?
Your Honor, I'm referring to the tax declaration, Your Honor.
So precisely, there's no acquisition value.
Indicated here, no, Your Honor.
How was
There's
that acquired? Was it by donation, inheritance, or what?
Your Honor, this is by purchase, Your Honor.
By purchase. So
Yes, sir.
there is an acquisition value if you buy a property.
Yes, Your Honor.
All right. Go ahead.
In that light, Your Honor, before I further proceed, the witness who should have identified it, considering the stipulation as to the authenticity of the document and as to the competency of the witness, is Engineer Mario Badillo, the head or the city assessor of Makati, Your Honor. If allowed to testify, he should have established the accuracy of the entries of the SALN as of December 21, 2010, and likewise the assessed value and fair market value as approved and determined in the assessor's office of the city of Makati,
I
Your
think
Honor.
that there's no problem about that.
Yes,
Is
Your
there
Honor.
from the side of the prosecution?
Yes, Your Honor.
Good afternoon, Mr. President.
Yeah.
That is not exactly the stipulation that we are offering.
What is the stipulation?
The stipulation that we are offering is to the effect that we are not questioning the authenticity of the tax declaration, but that does not go into the accuracy of the values reflected in the SALN. That is our position, Your Honor.
So in that case, would you want us to present the witness? That statement was in connection, Your Honor, with all due respect, was for the purpose for which the witness would have been presented.
Because
and for us, if I may, it would be necessary such that at the end of the day, if we are to submit our formal offer of evidence, there is some reference point that we have to start with in connection with the submission of our evidence.
What is your pleasure? Are you do you want to present your witness?
Your Honor, we would like to, but in the light of their request last time, to agree and stipulate on this tax declaration, and in the light of the observations of some senator judges, to expedite this, we decided to stipulate with them. I think we are in agreement on the document, right, as to the authenticity.
As to the tax declaration, yes.
Yes, as to the tax declaration. The statement of the purpose is if he would have been placed on the stand, is the purpose, and that is for purposes of the record. Okay. Unless you want him to be presented right now, Your Honor, I will have to do that. You could stipulate that with me, only for purposes of the record.
Yeah, Your Honor, may I say something? We want to spare the Honorable Court with all these markings and trivialities, Your Honor. We will stipulate on the tax declaration and only on the tax declaration. If it goes into the accuracy of the SALN, we are not going to stipulate on that because the assessor, Your Honor, is not the one who executed the SALN, has nothing to do with the SALN of the Chief Justice. But he has got something to do with the tax declaration, for which we admit, Your Honor.
Your Honor, if I may,
Yes.
I think my statement was, if the witness would have testified, that was the purpose for which it was offered. I think we are in agreement as to the authenticity of the document. And following Rule 132, Section 23, I think the entries therein are deemed as prima facie. And that is the reason why we entered into a stipulation.
Let's stop this argumentation. There is no stipulation so far agreed upon because your minds do not meet. The prosecution will agree to stipulate with you only to the extent of the authenticity of the document and as far as the figures that was entered in that document, but as far as the accuracy of that document, they do not accept that. So Since that is the situation, then you present your witness.
Thank you, Your Honor. Can we request a 1-minute break? We'll
All
call
right,
the
1
witness.
minute break. General. Trial resumed. Majority Floor Leader.
Mr. President, may we recognize Senator Franklin Drilon?
The gentleman from
author.
Iloilo is recognized.
Thank you, Mr. President. Mr. President, during the break, we talked to both parties in an effort to make them agree on a stipulation in order to dispense with the presentation of this particular witness. And both parties agreed to the following stipulation, subject to their confirmation on record. The stipulation is that the entries in the statement of assets, liabilities, and net worth of the Chief Justice for the year ending December 31, 2010, marked as Exhibits 13 and 14, particularly the one that refers to a condo in Makati acquired in 2003. The entries under the column assessed value and current fair market value in the amounts of 726,000 and 1,210,000 respectively are based on the tax declaration, which is marked Exhibit 150.
Yes, Your Honor. And if I could make a very short addition to that, to the extent that it is copied from the tax declaration.
No, it is based on, if you change that, then you might expect. There is no difference between what you're saying and what I have proposed, which you have agreed upon during the break.
In that case, Your Honor, we will agree with that.
What about prosecution?
We likewise confirm that, Your Honor.
With that, maybe we can dispense with the presentation
Yes, Your
of this witness, Mr. President.
All right. Are you satisfied?
We are, Your Honor.
Did the statement of the gentleman from Iloilo accurately reflect the thinking of both the prosecution panel and the defense panel?
On the part of the prosecution, we confirm that, Your Honor.
How about the defense?
Yes, Your Honor, and my understanding is that it was copied and it is accurate to that extent. I agree, Your Honor.
Your Honor, I will have to object to the word accurate because that is the word that we are trying to avoid here. You cannot say that it is accurate because it does not reflect the current market value, Your Honor. Counsel is changing the stipulation.
No.
That is my manifestation, Your Honor.
No, Your Honor, that was based on the offer. But in that case, Your Honor, in order to expedite, and we will agree on that, Your Honor, based on the statement of Senator
When you say current market value today, or yesterday, or in 2010?
As of the time that the SALN was filed, Your Honor.
Yes. Why do you say that?
Because the SALN is dated at that time. For example, the SALN in question, it's a SALN dated December 31, 2010. So the current fair market value, Your Honor,
At that time,
it should be as of December 31, 2010. That is our position, Your Honor.
and what was written in the SALN?
What was written in the SALN were figures lifted from the tax declaration of the property.
So,
Yes,
all
Your
right,
Honor.
I understand.
Yes, Your Honor.
So, there's no meeting of the mind.
No, there is a meeting with the minds, Your Honor,
Yeah.
so that both of them have agreed to the stipulation as this representation has read. If the defense can confirm that.
Your Honor, this is just one little addition that as to the accuracy thereof, Your Honor.
We will not agree to the accuracy, Your Honor.
That is why we have not. That's why we said which stipulation is based on,
Yes.
there is no statement of accuracy because the other side will object to it.
Your Honor, if, okay, for example,
Well,
yes, sir. If it's what's based is it's accurate, then we will stipulate on that.
then I think I don't think we can have any stipulation with all those qualifications. We just proceed.
Present your witness.
Yes, Your Honor.
Yes, please stand up and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this impeachment proceeding?
Yes, Your Honor.
Do you?
Yes, Your Honor.